Welcome to Divorce 101, the New Jersey divorce process. You're probably here because you want to know, how do I start my divorce? What can I expect? I'm Bari Weinberger, founder of Weinberger Divorce and Family Law Group. I am a certified matrimonial attorney and have practiced family law for my entire career. I know this is not an easy time for you. I'm here to help you understand the divorce legal process and get you answers to your questions. So let's get started. The New Jersey divorce process can be broken down into a number of different stages. We will take a look at these stages today, from the beginning of the process, which is where you might be right now, right through to the conclusion of your divorce. Let's find out what you can expect. In New Jersey, the divorce legal process begins with one spouse filing a complaint for divorce. In the complaint, you state your grounds or the reasons why you've decided to divorce. New Jersey provides several grounds to choose from: irreconcilable differences, extreme cruelty, infidelity, which is adultery, and many others. You can choose one, you can choose several if they apply. New Jersey is a no-fault state, and many people gravitate toward irreconcilable differences, which is the main no-fault grounds. Irreconcilable differences simply means that a marriage has become irretrievably broken, but does not assign blame for this. You are not required to choose irreconcilable differences, however. Fault-based grounds are also available, such as drug addiction and extreme cruelty. Talk to your lawyer and find out which ground is best suited for your situation. Once you've filled out the paperwork, your complaint for divorce must be filed with the Superior Court in the county in which you or your spouse reside. The big question we often hear is, do you need to prove that your spouse actually did something wrong in order to get a divorce in the state of New Jersey? The answer is no, you don't. This is why New Jersey is called a no-fault state. Irreconcilable differences, for example, only requires you to identify that there has been a breakdown of the relationship for a period of at least 6 months. You don't have to identify what that breakdown entails. And that's the brilliance of this particular ground. Your complaint for divorce is, in fact, part of a public record. So when you choose irreconcilable differences, this means that your nosy neighbors, your employers, or anyone else who might be snooping around this courthouse and your documents won't find out anything about your personal matter. Isn't that a relief? No wonder this is the favorite divorce grounds for celebrities and others in the public eye. For many people, this can make a real difference for peace of mind. Because no one is being blamed for the divorce, it also means that you don't need to spend time in the divorce proving somebody else's fault, as you do when, for instance, adultery is the ground. As you embark on the divorce process, it's worth thinking about divorce mediation. Mediation is a way to settle your divorce out of court. It's neutral and confidential, and a fantastic option for spouses prepared and able to work through and negotiate the issues of their divorce with the help of a mediator. For mediation to work, both parties must be willing to be civil toward one another and accept compromises. Talk to your attorney about whether or not this is a viable option for you. Mediation can save considerable time and money over court litigation, making it a method of divorce worth exploring. So you have chosen for your grounds for divorce and you've filed the paperwork. What happens next? First, become accustomed to hearing yourself referred to as the plaintiff. After you, the plaintiff, file for divorce, you will eventually get copies of the divorce papers back from the courthouse. You will then have a period of time with which to serve your spouse with them, usually about 10 days. Your spouse, the receiving party, then becomes the defendant for the remainder of the case. Once papers are served, The defendant then has a period of 35 days in which to answer the complaint or otherwise provide a counterclaim. The counterclaim is when a defendant gets to say, I too want a divorce, and here are my grounds. What happens if the defendant doesn't answer the papers? The plaintiff has the option to say to the courts, look, I filed my complaint and the defendant never responded. I want to serve a default upon the defendant so that I can continue with the process without the defendant's participation. Sometimes this happens when you can't locate the defendant or the defendant is otherwise unavailable because, let's say, they're digging in their heels and they don't want to participate or they're just in denial. If the judge agrees that the defendant has defaulted, the divorce can actually proceed without the defendant's involvement. Here's a flowchart that describes this first stage of the divorce process. You can pause this slide now to take a closer look or go back after the presentation. On our website, weinbergerlawgroup.com, type the phrase divorce roadmap into the search box to see this on our site. So how are you doing? Is your first stage of divorce what you expected it to be? Next, we move on to stages 2 and 3 of the divorce. These stages focus on the case management process and the discovery process. Let's first look at what happens during the next step, the case management conference. Within 30 days of the filing of the answer to the complaint or the defendant's counterclaim, a case management conference will be scheduled with the court. At this conference, attorneys establish deadlines for discovery. This meeting is very administrative in tone. A judge or an administrator with the court will be present at this conference depending upon the county. When discussing dates for discovery, it will be discussed whether experts need to be brought in to share information and which kind of expert. An example of this would be if there's a business valuator being needed to appraise a family business. Something else that may be very important for you are temporary motions. Many of you want to know whether or not you can get immediate relief for things like child support, child custody, and spousal support before you actually get divorced. It's true, you don't need to wait until your divorce is final to get these things. If you need immediate relief, we have something called pendente lite motions, and that's just the Latin term for pending the litigation. What this essentially means is that up until the time that your matter is finalized, you can ask the court for temporary relief by filing a motion for temporary child support, temporary custody, parenting time plans, temporary alimony, and so on. Some spouses are able to work out temporary agreements on their own to cover these issues while their divorce is pending. However, be aware that you actually can go to court if you're unable to come to an agreement on your own. Are you a parent? When custody and parenting time issues are present in divorce, the courts send the parents to court-mandated parenting mediation. This is the court's way of saying that we're going to try to make you work out custody and parenting time on your own, but we're also going to try to help you do it. The court has staffed mediators at the courthouse who will actually assist you. You and your spouse attend together without attorneys, and you sit with the courthouse mediator to attempt to work through the issues. You don't walk in blind, however. You prepare with your lawyer in advance, so you go into the court-mandated mediation sessions with an understanding of which options for custody and parenting are actually in the best interest of your child. And because children are involved, parenting time and custody disputes are considered an absolute priority for the courts. In advance of having to go to a final trial or hearing, the court will also require you to attend court-ordered parenting classes. You may be thinking, I don't need parenting classes, but the point of the parenting classes offered through the court is not to tell you that you're a bad parent or to tell you how to better parent your children. Instead, it's to give you an opportunity to understand how the court is handling the custody and parenting time issues in your matter so that you can understand how these will be facilitated through the divorce process. You and your spouse will be directed to go to the court in an evening, but you're given different dates so you don't actually have to sit in the room at the same time as your spouse in case there's a dispute. You will have an opportunity to ask questions of the available people there, usually even with a judge and a mediator on site. You're also going to be expected to propose parenting schedules, custody, and parenting time plans. This helps facilitate agreements and settlements so that your matter can be resolved out of court and as amicably as possible through the court-ordered mediation we just talked about moments ago. If you can't resolve your parenting issues through negotiation or mediation, the court will want custody experts to become involved as a way to help resolve the matter. The expert might include a child custody evaluator or social worker or related expert. The case management order will reflect the need for experts and the amount of time that will be needed for the experts to gather information and prepare the reports and custody recommendations. Custody investigations and evaluations are imperative when there are custody disputes. If the judge orders an investigation, child and parenting experts meet with you individually, your spouse individually, you and your children together, your spouse and your children together, and then render a report. In it will be recommendations as to who will serve as the parent of primary residence, who will serve as the parent of alternate residence, whether or not there should be supervised parenting, and so on and so forth. This is called the best interest of the child report. In a private evaluation, either of you can choose to have an independent expert evaluate your family's situation and render a report. You will need to pay for these experts on your own. Or, of course, you can get joint experts where you and your spouse can share in the cost of just one expert, and that person will be neutral as they investigate and evaluate your family as a whole. Some questions that commonly come up around this area are, should my child go to court with me? And if so, can my child indicate what are his or her preferences for what parent they will live with? In most cases, the judge wants to make this a last resort, so keep that in mind. Occasionally, a judge may want to speak with the child, but will usually do so only in chambers to avoid the trauma of the court experience for the child. In most situations, preventing children from feeling the tug of war of their parents is usually the healthiest option. What happens with financial experts? Depending on your financial situation, your divorce case may require financial analysis and expert input. Dividing assets and debts, determination of alimony, and child support are common issues that require analysis. If you own a family business or business partnership, a business valuation may be needed. You will determine at the case management conference if the participation of financial experts are required in your case. Possible experts include forensic accountants who will go in and investigate certain assets, such as a business investment. In certain situations, especially if commercial real estate is involved, a real estate appraiser may be needed. You may also require a pension appraiser for complex retirement assets, or even a vocational expert. You might be thinking, what's a vocational expert? If your spouse was a stay-at-home parent for a particular period of time during the marriage, for example, but still retained skills and a capacity to work outside of the home, a vocational expert may perform an analysis and come up with an income value that may be imputed or projected to that spouse. And that particularly can impact alimony requirements. Let's talk about discovery for a moment, or the formal exchange of information in the case. Spouses exchange case information statement documents they have each prepared. The case information statement is, in my opinion, the lifeblood of almost every divorce case. Guidelines for further discovery are discussed at the case management conference, including what kind of information must be produced and by what date. So let's look at the case information statement. This is a document that provides vital information about you and your family. It talks about your respective incomes, identifies your household budget, your shelter costs, your transportation costs, your personal costs, not just for you, but for your whole family and your whole household. How are you living? What are your grand total monthly expenses in a net capacity? At the end of the day, how much are you earning, net dollars, versus how much is going out to care for your total house, and then what is left for savings? The net worth statement also identifies the delineation of your assets, everything, all in, you, your spouse, as well as joint assets. It also identifies your total debts. What are your liabilities? The case information statement tells the court exactly what exists. Sometimes going into divorce, you just don't know. Sometimes it has to be determined, and that's the brilliance of the discovery process in a divorce case. You see it all laid out before you. When a spouse in a divorce fills out the case information statement with a lot of "I don't knows," we have to investigate. We have to figure it out. We do that through the next phase, which is document demands and interrogatories and depositions. Sometimes we have to send out subpoenas and we have to ask companies to identify records and bank statements and credit card, monthly statements, deeds, and even title documents. Sometimes the other side must answer interrogatories, which are questions that we pose so that we can elicit the answers necessary for us to fill in the blanks and put the puzzle pieces together. We want to create the case most beneficial for our client to move forward with a financial settlement package that is fair and reasonable for the whole family. Depositions are used when there are still missing pieces. We then put the other side, or an expert even, in a room and say, we have questions for you. And while you're in a conference room, in my office, and we're all comfortable, there's a stenographer at the end of the table, and that person is recording everything. The person giving testimony in the deposition is under oath, and they have to answer these questions as if they were on the witness stand, sitting in a court of law. Stage 2 and 3 also has a flow chart here, case management and discovery, so that everything that we just discussed is available to you for review. You can hit pause now and view it, or come back during the replay. This flowchart is also available on our website. Type Divorce Roadmap in the site search box and you'll easily be able to find it. It's now time to start working with all the information that has just been produced, and hopefully now we can reach a settlement. The courts offer a few ways to do this through an early settlement panel and economic mediation. Remember, trials are expensive, they're burdensome, and most people want to avoid them. And in fact, most people are successful in avoiding them. In New Jersey, less than 5% of all divorces that are filed in the state actually result in trial. It doesn't mean that we don't go to court. We actually do go to court quite often, but it's for things like case management conferences and motions. But very few matters actually end up at a full-blown trial. This is because of early settlement panel and economic mediation, opportunities that the courts offer to us to help facilitate a settlement and avoid trial, and they really do work for so many people. Let's take a look at what they entail. So what is the early settlement panel? This is a process by which either 2 or 3 experienced volunteer family law attorneys come together, depending upon the county. They sit in a room with your respective position papers so they know exactly what you're looking for in a final settlement. They also receive your case information statements and other financial documents, and they analyze them. This panel has no axe to grind. They're not interested in you personally. They don't know who you are. They're there as independent, neutral people, and their recommendations are confidential. They think as follows. If they were the judge looking at this case, what would they do? What would they recommend as a final settlement? Your attorneys present your positions to this panel, and the panel gives you their recommendations. If you agree with the recommendations, you in fact could get divorced that very day before leaving the courthouse. And for many, this is a big incentive. However, most of the time, the panel's recommendations serve as a really solid foundation to assist you to move forward into extremely productive discussions for final resolution. Economic mediation is the very next step. If you don't resolve your matter at the early settlement panel, you go to economic mediation next. The 2 lawyers choose an economic mediator, somebody that they believe is qualified to assist you in reaching a settlement. All of you go to that person's office and you sit and you work together. The economic mediator's time is free for the first 2 hours generally. 1 hour of their advanced preparation time, because they will get your early settlement panel papers in advance and they will review them. And generally, there's also 1 hour of free face-to-face time. It's called economic mediation for a reason. They only talk about financial issues. They will not generally discuss custody and parenting time. Deciding what happens to assets and other economic issues can be cause for conflict. The court is putting together these steps to try to keep your matter out of trial. It's another brilliant opportunity to get you into a room for settlement purposes. Here's another flow chart that identifies the stages of early settlement and economic mediation for your review. And again, it's available on the website. In the event early settlement and economic mediation are not successful, the court sets forth another opportunity to settle before heading to trial. So what's next? Let's look at stages 6 and 7, intensive settlement conference and trial. Intensive settlement conference occurs when the early settlement panel or economic mediation has not been successful. We have this one final measure before an all-out trial is needed. In an intensive settlement conference, you and your spouse and your lawyer spend an entire day at the courthouse to try to resolve your case. You're generally there from the very beginning of when the courthouse opens to when the courthouse closes. A judge is usually committed to trying to give you as much time as possible to assist you in resolving your case. The judge will give you feedback and try to help you narrow your issues so that you can come to terms without moving forward to trial. If the intensive conference doesn't work out, you move to the next stage. Yes, the trial. If you go to trial, the trial court typically gives your attorneys a document in advance that lists everything that's necessary to submit before the trial, such as exhibit lists, witness lists, trial briefs, and other types of advanced demands. At the trial, the judge listens to testimony from you, your spouse, experts, other witnesses, and ultimately will have to render a final decision based upon all of the evidence presented. There is no jury at a divorce trial. The judge will determine what is right as to all unresolved and disputed issues, including final custody orders and final orders concerning asset division, instructions, as well as debts. Here's a flow chart on that intensive settlement conference and the trial phase, the stage 6 and 7. And like all other flow charts, find this one on our website under Divorce Roadmap, or hit pause and take a closer look now. Once you're divorced, be aware that in the future, you may need to enforce or request modification of the judge's orders as needed. So let's see what that entails. Let's say you finally have a divorce and you have your settlement terms, including a child custody order, and let's say your spouse is not complying with those orders. You can go to court and ask the judge for enforcement of the order. You tell the court that there has been a violation, essentially stating something along the lines of, my spouse, ex-spouse, has failed to comply, and I would like you to hold them accountable for their failure to abide the terms of the order or agreement. This is called a motion to enforce litigants' rights. In it, you can ask the court for some type of remedy, whether it's for parenting time related issues, visitation, support related issues, and so on. You can also ask for an order to be modified or changed. If you're paying alimony and you hurt yourself at work and are now on disability, for example, you can ask the courts to lower the payments stated in your order or agreement due to your reduced income. The circumstances of your particular situation must be substantially changed for the courts to approve a modification. Any request will be carefully examined. Talk to your lawyer about whether you have a modifiable issue and if your conditions are appropriate for such an application. This is Divorce 101, the divorce process. I'm hopeful that this has given you an overview of just what can be involved when you file and the stages that follow. It was a pleasure to give you information to answer some of your preliminary questions. If you have other questions, don't hesitate to reach out. Our telephone number is here as well as our email address. Please be in touch. We are available for free, confidential initial consultations. It is a challenging and it's a complex process, but you don't have to go it alone. With the right information and education and tools, you will make decisions that are right for you and your family. Take time, ask questions, and reflect on the best course of action to take. Good luck, and it was my pleasure to provide you with this information today. Please be well. Thank you and take care.